Much obliged, my lord. My lord, my team code is C. I am counsel number 1 appearing on behalf of the respondents, and I will be dealing with issues 3 and 4. If my lord permits, I would like to begin with my statement of jurisdiction. My lord, the respondent humbly submits to the jurisdiction of the Honorable High Court of Saurashtra in response to the petition, writ petitions and PIL filed by the petitioner under Article 226 of the Constitution, challenging the constitutional validity of the Saurashtra Animal Preservation and Amendment Act 1995 for alleged, my lord, alleged infringement of fundamental rights enshrined under Article 14, 19, 1G and 21 of the Constitution, my lord. If my lord would permit, I would like to begin with, if my lords are well versed in the facts of the case, may I please begin with my argument? Please. Much obliged, my lord. My lord, a very important issue at present is to be dealt with by the Honorable High Court of Saurashtra, my lord. My lord, the petitions in the present case have filed the writ petition challenging the constitutional validity of the present Amendment Act, alleging the fact that it violates a person's right to food, which is a part of right to privacy under Article 20 of the Constitution. Therefore, my lord, a very important question to be dealt with by the Honorable High Court is whether right to choice of food is a part of right to privacy under Article 21 of the Constitution or not. My lord, right to privacy has been very recently in the case of Justice case Swami vs. Union of India has been held to be as a fundamental right exclusively as a part of Article 21 of the Constitution. My lord, in the judgment of this case itself, this right has been given a very wide scope and a number of aspects have been included into purview of right to privacy, expressly held to be a part of right to privacy. My lord, a very important fact which is to be noted is one very important issue which is not been made the part of right to privacy in the judgment, my lord, is right to choice of food. My lord, during the careful reading of the entire judgment of Justice K.S. Swami vs. Union of India, it becomes very clear that right to choice of food is not a part of right to privacy under Article 21 of India. As my lord, nowhere in the entire judgment has there been any mention, any express provision mentioning that right to choice of food is a part of right to privacy under Article 21. Even the words, my lord, choice of food have been completely absent from the entire judgment. In the furtherance of my argument, my lord, I would like to cite a case law, my lord. If my lord would please refer to page number 21 of the memorial, my lord. In the Supreme Court in the case of Pulparambil Vasudevan versus Nanganathar Pulparambil Devadasan and others. In this case, my lord, the Supreme Court has held that the provisions for a law to effect another provision of the law, such provision must be expressly provided for. If my lord would permit, I would like to read the small extract of the judgment given on page number 21, my lord. Much obliged, my lord. My lord, in this judgment under para 19, Justice Nariman has held that for a provision of a statute to be an express provision affecting another statute or part of it, it would have to refer in so many words to the other statute or to the relevant provisions of it, and also to effect intended to be produced on it. Failing this, it could hardly be said to be express. My lord, it is very clear from the above judgment, as I have mentioned in the extract, my lord, that the Supreme Court's intention clearly shows of excluding right to choice of food from the purview of right to privacy, my lord, that they do not consider right to choice of food to be a part of right to privacy under Article 20. Secondly, my lord, in numerous case laws since 1958 till 2008, my lord, in numerous case laws whenever there has been a question of whether slaughter of cows and its progeny is constitutional or not, the Supreme Court has time and time again held that it is constitutional. In the case of state of Gujarat versus Mirzapur Moti Qureshi Kasab, my lord, the Supreme Court has held that even a total prohibition of slaughter of cows is not a violation of fundamental right, it is merely a reasonable restriction. If my lord would please refer to page number 22 of the memorial, my lord, a small extract from the judgment is given. If my lord permits, I would like to read out the extract, my lord. My lord, in this case, it has been held that in the present case, we find the issue relates to a total prohibition imposed on slaughter of cows and her progeny. The ban is total with regard to slaughter of one particular class of cattle. The ban is not on the total activity of butchers. They are left free to slaughter cattle other than those specified in the Act. It is not that the writ petitioner respondents survive only by slaughtering cow progeny. They can slaughter animals other than cow progeny and carry on their business activity. From the above judgment itself, it is very clear that the Apex Court does not consider right to choice of food to be a part of right to privacy under Article 21, as prohibition of slaughter of cows in the eyes of court does not infringe any fundamental right of an individual. If my lords are satisfied with my arguments, may I please begin with the next issue? Much obliged. My lord, the next issue to be dealt with by the court at present is whether the provisions of the present Amendment Act are violative of rights under Article 21 of the Constitution or not. My lord, firstly, the Article 48 of the Constitution, my lord, Article 48 of the Constitution expressly gives powers to the state to make laws in relation to protection of cows and its progenies and also prohibition of slaughter of such cows, calves and other milch and draught animals. My lord, Article 48 states that the state shall endeavour to organize agriculture and animal husbandry on modern and scientific lines and shall in particular take steps for preserving and improving breeds and prohibiting the slaughter of cows and calves and other milch and draught animals. My lord, from the reading of Article 48, it's very clear that it does not have any religious sentiments attached to it, and therefore, my lord, no religious rights of any individual will be violated under Article 48 of the Constitution. Secondly, my lord, Article 28 cannot include each and every right given to an individual, my lord. Only core rights which are necessary for the survival of a human being can be included under Article 21. In my lord, Hinsa Virodak Samiti State of versus Mirzapur, Modi, Qureshi, Jamaat and others, the court has held that fringe rights are one which are merely desirable to make life comfortable or more comfortable or luxurious. He urged, in the present case, the petitioner is not only claiming the right to food but claiming the right to particular food in a particular geographical area, which is the state of Saurashtra, which right is not protected by the Constitution of Hindustan. If such a right is held to be a part of right under Article 21, the same would be available to even foreigners. Mara, just 30 seconds, I am just concluding, Mara. Just 30 seconds more. The right to have food of one's choice is not a part of right to make a meaningful life. My lord, it is very clear from this very judgment of the Honorable Supreme Court itself, my lord, that right to choice of food is not part of right to live a meaningful life, and therefore, my lord, this act does not violate in any way Article 21 of the Constitution. If my lords are satisfied with my arguments, may I please call upon my co-counsel to further his arguments.
Can you just clarify right to privacy and right to this right to life being dignified and right to meaningful life, as you said?
Of course, my lord.
Because the wording used is right to live with dignity.
Yes, my lord.
I have never heard meaningful life. So can you just explore?
Yes, my lord. Sure, my lord. At present, I do not have the case law at present with me. My lord, the case law is Sheikh Zahid Mukhtar versus state of Saurashtra in the High Court of Saurashtra itself, my lord, in the year of 2016. The justice spoke, the judge in the court had held that right to choice of food. My apologies, my lord. That in this present case, my lord, they have held that another aspect of a human being under Article 20 of the Constitution is right to live a meaningful life, my lord. So a lot of different instances have been included under right to live a meaningful life, such as sexual orientation of an individual, family life, home, personal decisions that affect another individual matter. This have been included in the judgment of Sheikh Zahid Mukhtar versus the state of Saurashtra, which has been decided in the year of 2016 by the Saurashtra High Court. One more time. Even in the case of Hinsa Virodak Sangh as well, my lord, although the case law has been held that cow slaughter is not unconstitutional, even in the same case, my lord, the Supreme Court has held that right to meaningful life is also inclusive of Article 21 of the Constitution. If my lord is satisfied, may I please call upon my co-counsel? Much obliged.
Lordship, the counsel seeks permission to approach the dais. So oblige your lordship. Lordships, counsel number 2 appearing on behalf of respondent in the incident case which deals with the infringement of fundamental articles guaranteed under Article 14, 19(1)(g), Article 21 and Article 301 of the Constitution by the application of various provisions provided for under the Amendment Act, that is the Saurashtra Animal Preservation Amendment Act. In the incident case, the counsel would be dealing with issues 1, 2 and 5. Your Lordship, the counsel would be dealing with issues 1 and 5 together and then would be moving on to issue 2. If your Lordship's grant me permission, I would like to begin with my contentions. Your Lordships, issue 1 and 5 in the incident case deal with the maintainability of the writ petition and public interest litigation filed by the petitioner in the incident case, while issue 5 deals with whether on a conjoint pleading or the various fundamental rights, directive principles of state policies and fundamental duties provided for under the Constitution, whether by the application of the said provisions of the Infringed Act are ultra vires to the part 3, 4 and 4A of the Constitution. The council would be dealing with issue 1 and 5 on 3 basic aspects. First, the council would be providing a social background, a social structure which exists in the state of Saurashtra. Then I'll be moving with the constitutional provisions which provide consonance to the said Amendment Act which has been brought by the state legislature. And thirdly, I'll be providing with the various judicial precedents and judicial decisions given by the Apex Court of Hindustan in the ancient case. Your Lordship, Hindustan is a country which comprises of 80% Hindus, and for most of them, the killing and consuming of cows is a sin on religious and traditional grounds. In the Hindu religion, cow is referred to as mother or Gau Mata and is associated with the worship of Lord Krishna. In Hindustan, cow has been considered sacred, in fact, worshipped by the Hindu community. The slaughter of cows is therefore not an indigenous Hindustan practice. We have to respect that. It has been a tradition that has been upheld for thousands of years, even by non-Hindu kings and rulers as diverse as King Babur and Hyder Ali. Now, in light of the issues raised by my counsels appearing on behalf of the petitioners, specifically in clause 5 of their prayer, which deals with the state government shall make bulls and bullocks available for sacrifice on the auspicious occasion of Bakri. In light of this issue raised, I would like to bring to the Honorable Court's attention. In the case of State of West Bengal, Lordship, the highlighted portion of the instant judgment. In the State of West Bengal and others versus Ashutosh Lahiri, the court has noted that sacrifice of any animal by Muslims for the religious purpose on Bakri does not include slaughtering of cow as the only way of carrying out the sacrifice. Slaughtering of cow on Bakri is neither essential nor necessarily required as part of the religious ceremony. An optional religious practice is not covered by Article 25, subsection 1. On the contrary, it is a common knowledge that cow and its progeny, that is bulls and bullocks and calves, are worshipped by the Hindu on specified days on the festivals of Diwali and other festivals like Makar Sankranti and Gopashastami. A good number of temples are to be found where the statues of Nandi or bull are regularly worshipped. So this was for the social aspect of the ancient case. Now I will be proceeding with the various constitutional provisions which give effect, which basically held the legislative action taken by the state. It's in consonance with the constitution. Now, the complete ban on slaughter is in consonance with Article 48, Article 246 and Article 51A, subclause G of the Constitution of Hindustan. Now, firstly, dealing with entry number 15 in the state list provided for under Article 246 under the 7th schedule to the Constitution of Hindustan, which provides and lays down as under state legislatures shall be empowered to make laws with respect to preservation, protection and improvement of stock and preservation of animal diseases, veterinary training and practice. This means that the enactment of laws banning the slaughter of cow and its progeny is within the exclusive power of the state legislature. That is why various states have enacted their own laws banning cow slaughter to various degrees. And there are certain states such as Kerala and the northeastern states where there is no such law. This also explains to why there is no central law on this subject. Secondly, Article 48 of the Constitution lays down a directed principle of state policy which directs the state to prohibit cow slaughter by providing as under organization of agriculture and animal husbandry. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall in particular take steps for the preservation and improvement of the breeds and prohibiting the slaughter of cows and calves and other milch and cattle. Furthermore, under clause G of Article 51A provided for under Part 4A of the Constitution, casts a compulsion on every citizen of Hindustan that it shall be the duty of every citizen of Hindustan to protect and improve the natural environment including forests, lakes, rivers and wildlife and to have compassion for living creatures. Therefore, it should be clear from the outset itself that the Constitution itself requires the state to enact laws to ban cow slaughter. The language used in Article 48 affirms the legislative intent to attribute a sense of sanctity to the cow, keeping in mind the Hindu tradition. In fact, the directive principles gives the state unfettered powers under Article 31C, which I will be dealing later on, to legislate on slaughter of cows. Article 48 of the directive principle of state policies provided under Part 4 of the Constitution was a guiding principle for laws to be framed after independence. In 1958, legislations were brought in the state of West Bengal and Assam. In 1954 in Gujarat. 1955 was another big year when legislations were introduced in Uttar Pradesh, Punjab, Bihar, Himachal Pradesh and Haryana. After that, we saw the same in the states of Tamil Nadu, Madhya Pradesh, Odisha and Karnataka. It's a established fact that currently 24 states out of the total 29 states in the Union of Hindustan have some sort of legislation related to beef and cow slaughter. Now, it's just a question of following the law of the land. Now, I would like to direct your lordships lordships, please grant me some time to wind up with my. I would like to draw your lordships' attention to page 14 of the memorial submitted by the respondents. the last paragraph there. In the case of Mohammad Hanif Qureshi versus State of Bihar in the year 1959, which was decided by a 5-judge constitutional bench of the Supreme Court, the Supreme Court categorically held as under a total ban on the slaughter of cows of all ages and cows and calves of she buffaloes, male or female, was quite reasonable and valid, and in consonance with the directive principles laid down under Article 48. Moving forward, a total ban on the slaughter of she buffaloes or breeding bulls or working bullocks, as long as they are capable of being used as milch or draught cattle, was also reasonable and valid. Now, furthermore, acknowledging the Gujarat government's version, comparing the dung of a cow to a Kohinoor diamond, the Supreme Court, in the landmark judgment in the case of State of Gujarat versus Mirzapur, Moti, Qureshi, Kasab, Jamaat and others, observed as follows. This is a land of Mahatma Gandhi, Vinoba Bhave, Sant Mahavir, Buddha, Nanak and others. It will be an act of reprehensible ingratitude to condemn cattle in old age as useless and send them to slaughterhouses. We have to remember the weak and meek need more protection and compassion, and this was the following observation made by the Apex Court. Thus, on conjoint reading of the various articles cited before the Honorable Court and various judgments cited as decided by the Apex Court, it is proved beyond doubt that the present petitions brought before the Honorable High Court of Saurashtra are not maintainable in the light of above articles and judicial precedents cited. If your Lordship would grant me permission, I would like to proceed with my contention was issue number 2. Now, issue number 2, which Lordship, just 5 minutes and I'll be concluding with my argument. Whether the provisions of the Amendment Act are violative of fundamental rights provided for under Article 14-19 of the Constitution. It is humbly submitted before the Honorable High Court of Saurashtra that the present Amendment Act, which has been formulated by the state in order to give effect to the powers conferred under Article 48 of the Constitution, are in consonance with the Constitution. Now, I would like to bring your Lordship's attention to Article 31C. Article 31C provides for.
Your Lordship, Council would just like to submit, would just like to make a submission. Your Lordship, right to equality should also be maintained here, and hence, if there is a time limit, we should prescribe by it, I guess.
Your Lordship, it's specifically mentioned in the rules of the ancient Moot competition that the time is solely at the discretion of the judges. So I think that issue is quite dealt with.
Your Lordship, fundamental right to equality, Your Lordship.
Your Lordship, the councils appearing on your petitions are free to extend the
Now 30 seconds to end.
Surely, Your Lordship. Now, Article 31C provides for notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing the principles specified in Clause B or Clause C of Article 39 shall be deemed to be void on the grounds that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14, 19 or 31, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Now, moving forward to this, the 42nd Amendment Act, which came into existence in 1946, further changed the article of.
Thank you. Wait.
Your Lordships, can I proceed with my prayer?
Thank you. We'll read it.
Only one suggestion. When there is a division bench, you have to produce 2 copies of the whatever you are given. Division bench will not share.
Show your Lordship.
That is the protocol. Please.
So I can just proceed with my prayer and I'll just wind up.
We'll read the prayers.
Much obliged.
Wait for the questions. How can you tell that? No. What steps have been taken by the government for the repercussions that will come after importing this ban? There are many things, many consequences. Any steps taken? What's the gist?
Your Lordships,
She doesn't have any mention in your petition.
Your Lordships, the Instant Amendment Act introduced by the Saurashtra Animal Preservation Amendment Act 1995 only bans the slaughter of cow and its progeny. So, as contended by the petitioners that the rights of the minority community as well as the butchers is being infringed upon by the application of the current provisions of the Act, it is to be brought to the notice that the Act only envisages to put a blanket ban on the slaughter of cow and its progeny. It does not cast a blanket ban on the slaughter of other animals. So the state, in order to respect the traditional, the religious feelings of a particular community, as well as to taking into account the the agrarian nature of the economy. More than 60% of the total population in Hindustan is directly or indirectly employed by the agriculture sector and is dealing with agriculture related economy. More than 50% of the total gross domestic product of Hindustan is generated from the economic sector, on the agriculture sector. So
Let's cut on. Please play. There will be certain repercussion of this.
yes, sure.
If I say not to slaughter, then what to do about that animals? Is the farmer able to take care of these animals, especially the dog animal or the animal which are not rich animals?
So, Lordship,
Not only slaughter or butchers have been affected, there are many allied industries that are being affected. Maybe leather, maybe transport, maybe cold storages, import and export, international revenue earned in foreign currencies by the government. What is the solution for that? Just in 1 minute.
Your Lordship, as mentioned by you in the while in the arguments of the petitioners, that even when a cow or its progeny becomes flawed, it has a lot of usefulness in the other sectors. Like the cow dung is used for manure, the urine of the cow is used for medicinal purposes. So even if the cow is kept alive and not slaughtered, I don't think it infringes upon any individual's right. As far as the question of import and exports that the country of Hindustan deals with in relation to the beef economy, I would just like to share one point. 60% of the total population of Hindustan is directly concerned with the